Hello everyone, welcome back to part 3 of Live Laws Limited series on the 3 new criminal laws. In part 1 and part 2, we have already covered the changes introduced by the Bharatiya Saksha Adhiniyam and Bharatiya Nagarik Sanhita, replacing the Indian Evidence Act and the Indian Penal Code respectively. Let us now come to the one remaining and one of the most important legislation of our criminal justice system, that is the Bharatiya Nagarik Suraksha Sanhita or BNSS, which has replaced the Code of Criminal Procedure. According to the Statement of Objects and Reasons of the BNSS, it aims to provide for a faster and more efficient justice system to address the issues of delay in delivery of justice due to complex procedures, low level of use of technology in the legal system, delays in investigation, and inadequate use of forensics. The BNSS has 531 sections and 37 chapters as compared to 484 sections and 39 chapters of the CrPC. The most difficult change for the law fraternity to cope up with is the fact that numbers of the sections in BNSS corresponding to those in CrPC have been changed. This is the same as in the case of BNS and the BSA. Let me take you through the new additions in the BNSS. Though we will not be able to trace each and every section, it is our endeavor to tell you about the major changes. We start with Chapter 2, that is definitions. 5 new definitions have been added, that is audio, video, electronic, bail, bail bond, bond and electronic communication. The definition of the word India, which was found in Section 2F of CrPC, has been deleted. The definition of metropolitan area found in Section 2K has been deleted. There is a change in the definition of victim, which was Section 2 Clause WA of the CrPC and is now Section 2Y of BNSS. The BNSS recognizes the victim as any person who has suffered any loss or injury caused by the reason of an act or omission of the accused person and includes the guardian or legal heir of such victim, in contrast with the CrPC, wherein victim meant a person who has suffered any loss or injury caused by the reasons of the act or omission for which the accused person has been charged. The word pleader in the definition of pleader has now been replaced by the word advocate. Next, we talk about the court's structure and offices. These are Chapter 2 and 3 of the BNSS. BNSS has rationalized the court structure by removing unnecessary classifications. The relevant sections dealing with metropolitan areas and metropolitan magistrates have been deleted now. The classification of metropolitan area was based on population. So there will be no more metropolitan magistrates and no more assistant sessions judges. As a result of this, let me tell you, the Delhi High Court on 2nd July in an administrative order redesignated the existing magistrate courts across the capital as judicial magistrate courts. Section 27, that is jurisdiction in case of juveniles, has now been omitted. Coming to Chapter 5 of the BNSS regarding the arrest of persons. Under this chapter, Section 35, subsection 7 prohibits arrest without permission of an officer of and above the rank of Deputy Superintendent of Police in cases where the offence is punishable with imprisonment for less than 3 years and the person to be arrested is weak, or in legal language as we say infirm, or is above 60 years of age. The police may, keeping in view the nature and gravity of the offence, use handcuffs while effecting arrest under Section 43 of BNSS. Identification of a person arrested by another person can now be recorded by means of electronic communication as per Section 54 of the BNSS. Coming next to Chapter 6 and 7, that is process to compel appearance and production of things. Under Section 64, summons can be issued in an encrypted or any other form of electronic communication. Section 86 provides for identification and attachment of property of proclaimed person. There is now a provision for recording of search and seizure through audio-video electronic means. Moving forward, let us discuss the changes under Chapter 13 of BNSS titled Information to the Police and Their Powers to Investigate. This chapter talks about an important concept of zero FIR. Earlier, as you know, under Section 154 of the CrPC, an FIR could be registered by the police only if the crime occurred within their jurisdiction. Though various Supreme Court judgments had mandated for compulsory registration of FIR irrespective of jurisdiction, now with the introduction of Section 173 subsection 1, when information regarding a cognizable offence is given to an officer in charge of a police station, he is bound to register it in the FIR book, irrespective of the area where the offence was committed. So, if information is given to the SHO of a police station in Punjab regarding commission of a cognizable offence at Kochi in Kerala, the SHO at Punjab is bound to register the FIR. Now, the police station where the report is filed then registers the case with the temporary number known as a 0 FIR and initiates the investigation. Subsequently, the case is transferred to the police station having the jurisdiction over the area where the offence took place. But remember, the jurisdiction of the magistrate and that of the police station continues to be the same as earlier under Section 156 of CrPC. Further, Section 173 also provides for registration of the FIR electronically. However, the signature of the person giving such information is required to be taken within 3 days before the eFIR can be taken on record. Next, it is quite important to understand in detail subsection 3 of Section 173. It talks about a process called preliminary inquiry for certain types of criminal cases. Basically, if someone is accused of a crime that could get them a prison sentence of at least 3 years but less than 7 years, the police can do a preliminary check to see if there is enough evidence to go further and investigate. The same shall be conducted with the prior permission from an officer not below the rank of Deputy Superintendent of Police. Pertinently, the inquiry shall be carried out within a period of 14 days in cases where there exists a prima facie case. However, in cases where the prima facie case already exists, the officer is required to proceed with the investigation. A point to note here is that a time limit to complete the inquiry has been given, but no time limit has been given to take permission from the senior officer. Another important point here is, all of us know that Constitution Bench of the Supreme Court in Lita Kumari versus Government of UP had held that when information regarding commission of cognizable offence is received by the SHO, he has to mandatorily register the FIR. This was because in many cases the police misuse their powers and have shown discriminatory attitudes towards the informants. Well, now the new Section 173 subsection 3 neglects this mandate of Lita Kumari. Next in this chapter, it is essential to discuss Section 187. A major change has been introduced through this section in BNSS, which is the new representation of former Section 167 of CrPC. This provision related to the period of remand which can be granted by a magistrate when an accused is produced before him by the police. The former section had given a maximum period of 15 days police custody, which could be granted within the first 15 days after arrest. There was legal battle in interpreting this provision of CrPC as to whether the maximum permission of 15 days police remand could be granted only in the first 15 days or could it span over the entire period of 60 or 90 days as the case may be, provided for investigation for the purpose of default bail. If you are interested to understand this legal debate, you must read two important cases. First, CBI versus Anupam J. Kulkarni and the recent verdict in Senthil Balaji versus State. Anyways, now the BNSS Section 187 subsection 2 has clarified that maximum permissible 15 days of police custody can be granted in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days as the case may be. This provision allows the investigating agency to seek 15-day police custody in tranches across the first 40 or 60 days of the investigation. This means that police custody can be sought in different spells beyond the first 15-day period after arrest. Moving ahead, the lawyers watching this video know the importance of taking cognizance of an offence. Taking cognizance is the first and foremost step towards trial. It is considered as judicial response to a crime or initiation of proceedings of an alleged offence by the magistrate. The Bharatiya Nagarik Suraksha Sanhita has brought a major change in this regard with Section 223 subsection 1. It has put a mandatory requirement for the magistrate to provide an opportunity of hearing to the accused before taking cognizance of an offence based on the complaint made to the magistrate. Where critics argue that this could lead to overburdening of judicial work and duplicity of proceedings at pre-trial stage, some on the other hand say that the new provision provides a layer of protection to an accused in the form of right to be heard before taking cognizance. Next, let me tell you about the change in the new law regarding the procedure for dealing with complaints against public servants in relation to acts in the discharge of official functions. In the case of a public servant also, BNSS enjoins that a magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in the course of the discharge of his official functions or duties unless he is given an opportunity to make assertions as to the situation which led to the alleged incident. This provision further obligates the magistrate to call for a report containing the facts and circumstances of the incident from the official superior. Further, the new procedural law under Proviso 2nd to Section 218(1) makes a provision of deemed sanction. That is, if a sanction is not received to prosecute the public servant within 120 days, the sanction would be considered as deemed sanction to prosecute the public servant. Let us now see the changes introduced at the trial stage. The first change is with respect to discharge. So we know that at the time when charges are framed, if the sessions judge finds that there is no ground or substance in the case, he can there and then discharge the accused. As per the CrPC, discharge of an accused and framing of charge against the accused was a continuous process and no application for discharge by the accused was contemplated. It was the duty of the sessions judge under CrPC to consider whether the accused deserves a discharge and if so, to discharge him even without the need for a petition. But Section 250 subsection 1 of the BNSS now specifically confers a right in the accused to file a discharge petition. It fixes a time limit of 60 days from the date of committal of the case to file the application. So now the sessions judge cannot frame charge within 60 days of committal of the case because he will have to wait for a discharge petition. Moving ahead, the Sanhita under Section 349 provides for the magistrate to order any person to give samples of his signature, handwriting, voice or finger impression for purpose of investigation without being arrested. Next, let me tell you about a new provision which relates to trial in absence of the proclaimed offender. The Code of Criminal Procedure provided for recording evidence in the absence of accused under Section 317. However, CrPC did not contain any provision for trial in absentia in the case of a proclaimed offender. In this regard, now, Section 356 of BNSS stipulates that if a proclaimed offender is not present, then the court can proceed to try him in 90 days from the date of framing of charge. The BNSS has formally introduced a witness protection scheme. Section 398 now requires every state government to establish such a scheme to safeguard witnesses. Previously, the Supreme Court in the year 2018 in Mahendra Chawla case had mandated this scheme as law until legislative action was taken. Despite the Ministry of Home Affairs issuing instructions on the witness protection scheme to all states and union territories in 2019, there was no legislative provisions in place until the enactment of the BNSS. The BNSS has added a new provision that outlines the process for presenting mercy petitions to the Governor and President in accordance with Articles 72 and 161 of the Constitution, respectively. After being informed by jail authorities about the disposal of the petition of a convict sentenced to death, he or his legal heir or relative can submit a mercy petition within 30 days to the Governor under Section 472, subsection 1 of BNSS. If the mercy petition is rejected, the person can file a petition to the President within 60 days from the date of rejection. No appeal against the order of the President can lie in any court as per the new law. After discussing these major changes section-wise, another aspect of the new act needs to be highlighted. That is, use of audio-video electronic means for investigation and trial. The BNSS has emphasized the significance of audio-video technology to aid the police in crime scene investigation as follows. Section 105 mandates that police officers must record searches and seizures via audio-video, document the items seized, and promptly forward the recording and seizure list to the authorities. However, there are certain provisos to this. Section 176 of the BNSS outlines investigation procedures, including an option for audio-video recording of statements. However, it specifies that for rape cases, the victim's statement should be recorded at her residence or a place of her choice, preferably by a female officer and in the presence of her family or a social worker. It further mandates that a forensics expert collect evidence at crime scenes for offences punishable with imprisonment for 7 years or more. Additionally, a police officer must videograph the process using mobile phone or other electronic device. As per the new Section 183, audio-visual recording of confessions and statements before a magistrate is optional. However, it is mandatory for individuals who are mentally or physically disabled. The BNSS also allows for audio-video recording of the test identification parade. But this is only required if the person identifying the arrested individuals is mentally or physically disabled. The new provisions also permit use of audio-video technology in judicial proceedings for evidence deposition by witnesses, police, public servants, and experts in sessions cases. Witness examination in warrant case trials and the accused's interrogation can also utilize audio-video conferencing at designated state government locations. Public servants are allowed to give their depositions using audio-video means as well. And with that, we wrap up the major changes introduced by the Bharatiya Nagarik Suraksha Sanhita. You are advised to refer to BEAR Act for thorough understanding. Where the object of the BNSS reads that it is to streamline the criminal justice system, aiming for a more expeditious and effective delivery of justice, there has been a large hue and cry about the hardships it allegedly brings. Like replacing CrPC despite minor changes, it is being seen by critics as unnecessary and confusing. The strongest criticism is that it gives police sweeping new powers to arrest, investigate, and prosecute without much oversight or accountability. Well, we like it or not, as the new criminal laws have come into force, the legal fraternity out there must update themselves with the new criminal law justice system. As this video is only a short summary of the changes introduced, you can visit livelaw.in and find multiple articles explaining the new important provisions in detail. Thank you for watching. Make sure to tell us in the comment box if you like this video and, more importantly, your take on the new laws. Keep watching Live Law for more such insightful legal content.